Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today on our channel, we'll be discussing two important cases in the field of criminal law. One would be Arnesh Kumar, followed by Satendra Kumar Antil versus Central Bureau of Investigation. And the other would be Chanda Kochar versus CBI. Now, talking about the first important case law in the field of criminal law. Now, the Supreme Court of India and Satendra Kumar Antil versus CBI laid down fresh guidelines on arrests in order to have strict compliance with the provision of Section 4141A of the Code of Criminal Procedure 1973. Now, these guidelines are in addition to the earlier ones, which the Apex Court had already laid down in the case of Arnesh Kumar versus State of Bihar in 2014. The court in the present case had also emphasized upon separate legislation on the law relating to bail and also with regard to issuing specific directions in this regard. And in the next segment, we'll be discussing about Chanda Kochar versus Central Board. Now, as we all are aware that there were the rise and fall of Ms. Chanda Kochar, wherein there were a series of allegations against the ICICI Bank's former MD and CEO, which had eventually led to her unceremonious exit from the bank after an illustrious career of 34 years. Now, she'd initially joined ICICI Limited in 1984, played an important role in establishing ICICI Bank during 1990s. She was the head of infrastructure finance and corporate banking business during that record, and she led bank's corporate and international banking businesses during 2005 and 7, and subsequently she was promoted to as joint managing director, chief financial officer in 2007, and at the top position as the managing director and CEO 2009. But it was in May 2018 that the bank had initiated inquiry against Kochar following a complaint about her alleged role in granting out turn loans worth rupees 3,250 crores to the Videocon group, which benefited her husband Deepak Kochar. Now, recently she was enlarged on bail. Joining us today on the virtual amicus to discuss both these very important cases in the field of criminal law is a very distinguished and a noted and a very respected lawyer who's based and practicing in before the Bombay High Court. So today we are joined by Mr. Kushal Mor, and just to give you all a brief introduction about our amicus for today's session, Mr. Mor did his law from GLC Mumbai and graduated back in 2008 after a brief stint of 1 year at Paras Squad and Associates. Mr. Moore decided to practice criminal law and joined noted trial court lawyer Mr. Prakash Shetty. He has been independently practicing since 12 years and has worked on complex matters in different spheres of criminal law, from narcotics to white collar crime. Some of the cases clients represented by him include Peter Mukherjee in the Sheena Bora murder case, Mrs. Chanda Kochar in the recent CBI action, DHFL ex-promoters Kapil and Dheeraj Vadhavan, Congress leader Shri Rahul Gandhi, Aryan Khan cruise ship, and NCP leader Nawab Malik, to name a few. So thank you so much, sir, for taking our time and for readily saying yes for doing a session. Anything that you wish to say about our channel before you start with your presentations?
Thank you, Jay. Thank you for the introduction. And it's a pleasure being here. And thank you so much for inviting me. Uh, I have not only heard, I have seen some of the talks conducted by you. They are very informative. And most importantly, like today, the topics chosen by you are so apt, given especially talking about the topic of today. It is so apt and seminal right now because of basically how the bail law has changed over the years. As you know, and you are a successful practicing advocate at Jaipur yourself. And as you know, bail was always the rule and jail an exception. But over the few years, uh, it has turned upside down, right? And wherein courts are reluctant to grant bail easily. Some of it is probably due to advent of new laws, especially the PMLA and provisions under the Companies Act and the SFIO investigation, etc., where economic crime has taken the forefront. And as soon as you say economic crime and the number of crores, suddenly court is reluctant to grant bail. And therefore, it is so important that the Supreme Court has also felt the need and taken time to pass a very detailed, exhaustive judgment in Satender Antil. And therefore, it's great to be here, and I'd love to shed whatever light I can on this.
Thank you so much, sir, for all the kind words. Really means a lot. Sir, the stage is set. The floor is all yours. Over to you, sir.
Thank you. Thank you. So I prepared a small slideshow because I think that helps. Like you mentioned already, let me share my screen and I'll go as per the slides. Right. It's clear, Jay?
Perfectly clear. Perfectly fine.
Great. So to start with, if you see the see the heading, it says personal liberty versus power of arrest, because that is the seminal issue, and that is the issue to be discussed as to the importance of individual personal liberty and the power of arrest available to investigating agencies under the various statutes. And in light of that, we will examine today the judicial pronouncements in Until as well as of the Bombay High Court in Chanda. So I just quote something which was said as far back as 1994. I'm sorry, it says 2014. Actually, Joginder Kumar is a case of 1994, wherein the Supreme Court had the occasion to say this in so many words, that no arrest just because it is lawful for a police officer to do, no arrest can be made because it is lawful for the officer to do so. Existence is one thing, and the justification for exercise is quite another. The police officer must be able to justify the arrest apart from his power to do so. Arrest and detention in police lockup of a person can cause incalculable harm to the reputation and self-esteem of a person. So the courts have always recognized that personal liberty is a value which is cherished by our constitution, has been always cherished, and that is what must be protected at any cost. So this was the observation in Joginder Kumar in 1994. However, even thereafter, rampant arrests have always been made. So therefore, a very important judgment in form of Arnesh Kumar came to be delivered by the Supreme Court in 2014. Arnesh Kumar brought out the section in CRPC, which is the section 41A to be more specific, wherein section 41A states that if an offense is punishable by less than 7 years, then ideally the police officer should give a notice, and if the person to whom the notice is issued appears in pursuance of that notice and gives all the cooperation during the course of investigation, then there is no need for arrest unless some criteria are met. This was a provision which was in existence, however, not followed. In Arnesh, the Supreme Court passed a very detailed judgment wherein it gave importance to 41 and said that although that was a case which involved some sexual offenses or 498A, if I remember correctly, the Supreme Court said that it will apply to all offenses and not just offenses under 498A, wherein the offenses are punishable by 7 or less than 7 years. So now let's see what 41 says. 41 says that officer can arrest any person without a warrant if it's a cognizable offense, and who is subject of a legitimate complaint, credible information, or credible suspicion that he has committed an offense. An arrest can be done for the following purposes. One is to prevent the person from committing more crimes. Second is for furthering the investigation. Third is to prevent a person from destroying any evidence while he's out, or to ensure the appearance of that person during the course of trial. 41A, this is the important section. 41A says police officer to issue notice when arrest of person not required. Such person obliged to comply with terms of notice, such person shall not be arrested. Exactly what I said. So basically it says that once you have a 41A notice issued to you, even though you're an accused in an FIR, and you comply with that notice, then unless some specific criteria are met, the police officer cannot and ordinarily should not arrest. This was not being followed at all. So, some directions came to be issued in Arnesh. Arnesh said that a checklist must be provided to all the police officers. The checklist should contain the specified clauses, which are more detailed in 41(1)(b)(2). IO should forward that checklist along with the reasons and that he has followed all the provisions when he is producing the accused at the time of remand before the magistrate. The magistrate also needs to record his reasons and see that the provisions of 41A are followed before the magistrate authorizes further detention of the accused. So, just to give you an idea of how it works, is that once a person is arrested, within 24 hours, he is required to be produced near the nearest magistrate. At that time, the magistrate, as per Arnesh, is required to check that the police has followed the safeguards provided in CRPC before arresting the accused. And if the magistrate finds that the safeguards are not being followed, then no further detention and that person should be released immediately. So Arnesh specifically laid down this in para 12 that the magistrate at the time of further remand should ensure that all the safeguards are followed, nothing is violated, because it concerns the liberty of an individual, right? And thereafter, Arnesh went a step further. If you see the last 2 points, where Arnesh said that failure to comply with these directions shall render the IO liable for contempt of court. So you see how seriously the court has taken the provision to go to the extent of saying that if police officers do not follow, because often it happens in our country that many judgments are passed but are given a go by when it actually comes for compliance or execution at the police station level. So being conscious of that, the court says that in case these directions are not followed by the officer, then he can be hauled up for contempt. Another step, that if the magistrate also does not record reasons, then even the magistrate is liable for departmental proceedings by the concerned High Court. So, seminal judgment, and I tell you, Jay, we, after passing of Arnesh, at every instance, we kept on telling the court that, see Arnesh, Arnesh requires no custody. Arnesh does not require arrest if our offense is punishable under 7 years. But I would say there was some acceptance, but not in the complete letter and spirit as it should have been, even by the courts, at least the lower judiciary. So, and this went on for so many years until recently when Until came to be passed and thereafter. Before Until, I just want to read a line in Mohammad Zubair. Mohammad Zubair was a journalist of Alt News, right? And he was arrested in several affairs across the country, or at least shown as an accused. While granting bail, learned CGI, Dr. Chandrachud, writes so in the judgment that Section 41, as well as the safeguards in criminal law, exist in recognition of the reality that any criminal proceeding almost inevitably involves the might of the state with unlimited resources at its disposal against a lone individual. So Zubair also not only recognized 41, but reiterated that Arnesh should be followed in letter and spirit, and that is 2022. Now, it was important to give you a background of Joginder and Arnesh because everything, to my mind, flows from Arnesh. Even the directions in Until somewhere flow from Arnesh. And therefore, the foundation, if you ask me, would be Arnesh versus State of Bihar. Now coming to Satender Kumar Antil. First question is, what was the need to pass or to frame guidelines in until by the Honorable Supreme Court? When the law exists, the judgments are there, and we are all clear on what the law on bail is. However, these are some of the reasons which are not only quoted in the judgment and some which have come to my mind. So first, the primary reason the Supreme Court thought that it required to pass guidelines is because of the continuous supply of SLPs seeking bail, which were coming up before the Supreme Court in dozens in the recent years. Second, like I said, initially bail had become an exception, and therefore naturally that continuous supply of SLPs. Arnesh was being given a go by or not being followed in letter and spirit. And another thing which is very prevalent in criminal law, and it's a tough time for us to explain to the client as to what might actually happen, is that there is wide discretion with the court while granting bail. So you may have a number of case laws which support your case, even in similar factual situation. The courts can take conflicting views because of discretion. So that was another reason why the court felt that some guidelines are required. And therefore, if you'll see, Antil talks about a lot of things, and I'll come to all of that. Antil also laid out 4 distinct categories and how to deal with those categories of cases. Another reason was that there's a lack of a bail act, which you mentioned right in the introduction, right? We don't have, like there is one in UK, which clearly defines on how to go about granting bail. So there is no such act in India. And last reason was of the situation of our jails. What I mean by that is not the quality of food or the place to sleep, but just to give you an example, Arthur Road Jail in Bombay has a capacity of 800 inmates. However, at any given point in time, it houses more than 3,500 inmates. So this is not just Bombay. This is the situation of jails across the country, where jails are filled to the brim, far over the capacity that they were built for. And the most unfortunate part is that more than 50% of those inmates are under trials. So we are indulging in pre-trial punishment, though we have presumption of innocence, though we know that a person, until proven guilty, is innocent. But still, the situation is that under trials are languishing without trial for years as a sort of a pre-trial punishment. So in these circumstances, Satender came to be passed. And now let's see what it says. Before that, before I start on what the judgment actually says, I think everybody is well aware, Article 21, protection of life. No person shall be deprived of his life or personal liberty except according to procedure established by law. This is the pivot on which the entire judgment of Satender Kumar Antil is passed. I will point out to you as to how painstakingly the Supreme Court has gone through each provision and tied it to Article 21 to give this article the importance that it deserves as to how liberty and deprivation of liberty, unless it is as per procedure established by law, how important that is. And therefore, Article 21 is the pivot which has guided the honorable judges in passing this judgment. Some of the examples. So, Satender is a very long judgment, and initially, before their lordships go into the actual provisions, these are some of the things that they have thought fit to cover. First is the concept of liberty. as to how liberty has been viewed right from the olden days, how liberty has been cherished, protected, and enshrined in our constitution. They thereafter go on to define bail, because bail is not defined in any of the provisions or any of the acts, not in CRPC, not in IPC. They further go on to define trial. Trial is again not defined in any of the statutes. Then they go into, again, the jurisprudence of bail being the rule. Then they also talk about presumption of innocence. And I would like to, in presumption of innocence, also they talk about that presumption of innocence is a facet of Article 21, and that should always inure to the benefit of the accused. And they also discuss the relevant provisions in various other countries, especially Commonwealth countries like Australia, UK, and how bails are being treated there, where mostly it is seen that it is a monetary sum depending on the crime, which if the accused is able to fulfill, then bail is generally granted. Right? But that's not, I mean, it varies from country to country. But that's just one observation. Now, the specific provisions which the Supreme Court has dealt with in Until. First is 41 and 41A. Going back to Arnesh. This is what the court has to say. The specific words that court says is the consequence of non-compliance with section 41A shall certainly inure to the benefit of the person suspected of the offense. Resultantly, while considering the application for enlargement on bail, courts will have to satisfy themselves on the due compliance of this provision. Any non-compliance would entitle the accused to a grant of bail. So, I mean, as simple as that, without going into the merits, without going into any other modalities of the matter, the court says, first you see whether there is 41 compliance. If there is no 41 compliance, without looking at anything else, you must immediately grant bail. In fact, I tell you, you can look up there. There is one judgment of Munawar, very recently passed by Supreme Court. It's a 5 lines order of the Supreme Court, wherein the court says, we have been informed by the council there is non-compliance of 41A. Without going into any other issue, we hereby immediately direct that the petitioner be granted benefit of interim bail. 4 lines order. So that is the importance Until has again placed on 41 and 41A. It thereafter goes on to quote paragraphs from Arnesh, and it thereafter laments that despite the dictum of this court in Arnesh, no concrete step has been taken to comply with the mandate of 40. What I was referring to earlier, that though Arnesh was a seminal judgment, though we kept on harping about it in every court, but the mandate clearly was not followed, and therefore the Supreme Court in Until once again reiterates, and the Supreme Court, CJI Chandrachud himself in Zubair again reiterates that Arnesh must be followed in totality and there can be no exception. So that is the first part where this court in Until talks about 41. Thereafter, it goes on to the provisions of 87, 88, and the power to issue summons, warrant, and non-bailable warrant. Again, so generally, when an accused is to be brought before the court, what the court is required to do is to issue a summons. A summons does not infringe on any right, does not infringe on your liberty. A summons is a notice to you that you are required to remain present before the court on so and so date. So the court in Until once again re-emphasizes that you cannot straight away issue a bailable warrant or a non-bailable warrant, because the non-bailable warrants involves interference in your liberty, because you are likely to be arrested. So therefore, only and only if the court is satisfied that the summons, though issued, has been received on the proper address, and despite the summons being issued, the person is not appearing, then in that case, first a bailable warrant is to be issued. And even after issuance of bailable warrant, if the accused fails to remain present, then the magistrate or the judge must record reasons before issuing an NBW. And says that this is also a limb of Article 21 and must be considered in that perspective. After this, the court goes on to another very important provision, which is provision of default bail under 167(2). So, as you must be aware or may not be aware, police is required to complete investigation actually within 24 hours. But since it is not completed in 24 hours, there are two sets wherein if the accused is in custody and the offenses are punishable by 10 years or less, then the police has a period of 60 days to complete the investigation and file the charge sheet. In the event that the police does not file the charge sheet within 60 days, then the accused is to be released on default bail immediately. Means it's a very indefeasible right. And again, it ties in with Article 21. How? Because Article 21 requires a speedy investigation. Somebody is inside, there is no charge sheet, there is only an FIR, he does not know what is the material against him. So the court strikes a balance, or the legislature strikes a balance, wherein says if the offense is punishable by 10 years or less, the police has 60 days. Within 60 days, you must file the charge sheet. If on the 61st day there is no charge sheet, then a right accrues to the accused, and the magistrate on a simple application is to release you immediately forthwith without going into any other modalities of the case. So this is what Until re-examines again. And a very important example, or a very defining example, is of the recent pandemic. Because during the pandemic, naturally everything was at a standstill. Even the police were functioning at limited capacity. The police were required to do so many other things as required for the pandemic, naturally. So in such a case came up before the court in Ravindran versus Director of Revenue Intelligence, wherein the charge sheet was not filed, and the investigation agency claimed COVID as a excuse to not file the charge sheet. However, after much deliberation, the court held that it does not matter that there was a pandemic, because somebody's liberty is at stake. That person was in jail, the 60 days have completed, and therefore the right of default bail will accrue to him, pandemic or not. So that was something, once again, that Until re-emphasizes and goes on to talk about Article 21 again, Maneka Gandhi, and thereafter, after default bail, the next thing it talks about is Section 170, but I will come to that later. Now, you see how much importance is given to Article 21 can be seen from the fact that the court, in a judgment where it's laying down guidelines for bail, has proceeded to talk about Section 309 of CRPC. Section 309 of CRPC says that a trial is to be conducted on a day-to-day basis. And in any event, adjournments should not be granted and should not be for more than 2 weeks, etc. And more than three adjournments should not be granted, right? So there was no real reason or cause for the court to go into the provisions of 309 when it's talking about bail. But why the court goes into 309 is the right to speedy trial. And this is what the court has to say. We are touching upon this provision only to show that any delay on part of the court or prosecution would certainly violate Article 21. This is more so when the accused person is under incarceration. This provision must be applied inuring to the benefit of the accused while considering the application for bail. Whatever may be the nature of the offense, a prolonged trial, appeal, or revision against an accused or a convict under custody or incarceration would be violative of Article 21. So, therefore, Until has gone on to the extent of saying that in case you're not getting a speedy trial and your right under Article 21 to a speedy trial is getting infringed, even in that case, the courts should grant you bail only on that ground. And lastly, it has taken note of the number of under trials and section 436A. Section 436A is again an indefeasible right, just like the default bail under 167(2), which says that once you have completed half of the maximum punishment for which you are being tried, then you are to be released on bail immediately. So the court in Until has said magistrates need to go and visit the jails, make a list of the accused who are facing trial and are lodged as under trials, and then find out which are the accused to whom this provision would apply and immediately release all of them on bail. Because as you know, the condition of some of the accused is so bad in jails that neither any family nor any legal aid nor anybody to even wonder that whether in fact, I mean, in some cases the accused serves almost all of his sentence without the trial being completed. So therefore the court has said that each high court will monitor this and the magistrates will visit the jail and ensure that under trials who have completed at least half their sentence will be released immediately. So in the first part, I mean, you saw the last slide. First, it spoke about liberty, what is bail, what is trial, the jurisprudence, presumption of innocence. Thereafter, provision by provision, the Supreme Court, not just bail, but went on to see where all the Article 21 can be infringed and said in no uncertain words that wherever there is a possibility, then bail should be immediately granted, even as gone as far as to say that right to speedy trial, if your trial is not being conducted speedily, then even that may be a reason for you to be granted bail. Right? Now, section 170, which was here, which I skipped, this was one other very important decision or very important finding of the Supreme Court, which said, and I'll explain the logic to you, which said that once an accused is not arrested during investigation, then thereafter there is no reason to arrest him, right? So let's understand how it works is this, that why does a person need to be arrested? And again, take you a few slides back. So here it says arrest required for the following purposes, right? To prevent the person from committing other crimes, investigation, destroying or tampering with evidence. telling the court or police about the facts, and ensure appearance of person. So if you see all the 1, 2, 3, 4 points, those are applicable only during the course of investigation, right? Sorry, not point one, but the investigation, destroying or tampering with evidence, and discouraging anybody. So these are all steps during the course of investigation. So therefore, generally, bail is opposed because the prosecution will say that if this person is released on bail, we may not be able to complete our investigation properly. Investigation is still pending, and therefore kindly do not release him on bail because he is a powerful person. He may influence the witnesses. He may, destroy some critical evidence for which we are yet to lay our hands, and so on and so forth. So now, for the first time in Amanpreet, actually, Amanpreet was the first one. Sorry, Siddharth was the first one where the Supreme Court said that if the accused is not arrested during investigation, merely filing of charge sheet does not entitle the IO to arrest the accused. This was followed in Amanpreet, wherein again the court said that there is no doubt in view of the judgment in Siddharth, and now it has been followed or again reiterated in Satender, wherein the court has clearly said that there is no question, and in fact, in the concluding para, where the court issues various directions, Until has gone on to say there needs to be strict compliance of the mandate laid down in the judgment of this court in Siddharth's case. So therefore, now wherever the prosecution has not arrested the accused during the course of investigation, means that the accused has appeared whenever called. The accused has given all the cooperation, the accused has given them whatever they required, and has not hampered the investigation in any manner. So therefore, now all that happens is charge sheet is filed, the court issues summons, and if the accused appears on the summons, the court will either release him on bail or merely by taking a bond under Section 88. In fact, the court goes on to say that if you appear in pursuance of a summons after charge sheet is filed, you don't even need to file an application for bail. And all that the court will do is to secure your presence, may take a bond from you saying that you will appear on the next day. So this is how far we have come, or how far Satender Antil has helped the jurisprudence of bail to progress suddenly in the last couple of years. And the last part in Antil, which is the oft-cited part, but like I showed you, there was the other seminal important things covered in the judgment. But the last, what the court does is it creates 4 categories of offenses, and I will quickly go through them. The category A is an offense which is punishable with imprisonment up to or less than 7 years. So in this, again, one is Arnesh, of course, and it says that after filing of charge sheet, taking cognizance, court should issue summons. Only if accused does not appear despite service of summons, then bailable warrant, then NBW, and NBW, of course, can be cancelled, and so and so. And last point, which I just told you, bail application be decided on his appearance without the accused being taken in physical custody or granting interim bail till bail application is decided. So one important thing which Antil says, which courts were dilly-dallying, that a bail application, always there is a power with the court to grant you interim bail until that bail application is decided. Because there is no specific provision in CRPC for interim bail. But Antil says the power to grant bail includes the power to grant interim bail also. Right? So that was category A. That was, I think, quite simple. I don't think there's any doubt about that. Sorry, excuse me. Now, category B is punishable with death, imprisonment for life, or more than 7 years. So the court says it is to be decided on merits and appearance of the accused. C is punishable under special acts. Now, what is the reasoning here to create category C? All of these which you read in the brackets, PMLA, NDPS, UAPA, and Companies Act 2126, all of these contain something called as the twin conditions, wherein these are in addition to the general restrictions on bail, mainly that the court at the time of granting bail needs to be satisfied that the person is not guilty of the offense. So you see how difficult that becomes, because actually bail is on a prima facie case. Whether you're guilty or not will be decided at the end of the trial. But these are stringent acts, each having ramifications. PMLA on the economy of the country, NDPS because narcotics, Companies Act, again, it's a serious fraud investigation office which investigates into those offenses. So, because these are acts which have wide ramification on the country or on the health of the economy or otherwise, therefore, the twin conditions have been put in, wherein the court needs to be satisfied that you're not, or reasonably come to a conclusion that you're not actually guilty of the offenses at the time of granting you bail, right? So, therefore, category C. And therefore, it says bail application to be decided on merits on appearance along with compliance of provisions of bail in the special acts. So those are the two conditions which I told you. The condition one is they should be satisfied, not guilty. Condition two is the prosecutor must be heard. Right? And category D is the economic offenses. Here, because any offense, what would be thrown by the prosecution is that it's an economic offense, very serious, very grave, and kindly, therefore, bail application needs to be rejected. So, therefore, in until a specific category is made of economic offenses, and until refers to the judgment in P. Chidambaram and says, though economic offenses constitute a class apart, but it is not that all economic offenses are grave or serious. Each case needs to be taken on its own facts, and that is all that is to be, that is all that needs to be considered for economic offenses, nothing more or nothing less. And whatever else is only when there are special acts under C. Right? So, I think there we sort of conclude until, but what I would say is it's a must read for everyone. It's a complete code or a digest on bail, wherein everything from the start till these formation of categories, the court has covered in depth. So that's a must read for any practicing advocate on this side. And now the sensational arrest, which unfortunately took place. I go back to my first slide of Joginder, which says power to arrest is one thing and the justification of arrest is another. Just because you have the power, you cannot just exercise it without any, exercise it rampantly, which is what happened in this case. And I give you a very brief. An FIR came to be lodged in 2018. Please see, we are in 23. The rest happened sometime in December 22. An FIR came to be lodged in 2018, and for the next 4.5 years, no arrest was carried out by the CBI. During these 4.5 years, there was a ED prosecution, there was a CBI prosecution, and whenever called, the petitioners appeared before the investigating agencies. I think before the ED, if I'm not wrong, they appeared almost 40 to 50 times in this course of 4 years. CBI, for some reason, chose to call them only twice. Both the times they appeared before the CBI, duly complied with whatever requisition was required, gave documents asked for. Suddenly, December 23rd, they are called and immediately arrested upon reaching the CBI office. The grounds of arrest which were there in the arrest memo say that they are not cooperating with the probe. Very vague ground, does not say anything. 41(1)(b)(2) clearly lays down what are the circumstances in which you can arrest, and non-cooperation with the ongoing probe is not one of those grounds. This is a very run-of-the-mill or usual thing for a investigating agency to say. Non-cooperation. What do you mean by non-cooperation? I mean, just because you are not getting the answer that you want to hear does not become non-cooperation. And there's a judgment, a very beautiful judgment of Bombay High Court, which says that merely because the agency is not getting the answer which it requires cannot be termed as non-cooperation. So anyway, this is what were the facts, so to say, in Kochars, where an FIR which was lodged more than 4.5 years ago, and they were called only twice and attended several other agencies, suddenly, out of the blue, came to be arrested on December 23, 2022. What went wrong? Illegally, arbitrarily arrested the petitioners, clear contravention of constitutional mandate, provisions of CRPC. No occasion whatsoever to arrest the petitioners. They had cooperated throughout. Violation of 41 and 41A of CRPC. And further, even the special CBI court, which was remanding the accused for further detention, and though we argued time and again that there is non-compliance, complete non-compliance, it was given a complete passover and a bleak reference made in the remanding order regarding Arnesh, but no finding given by the remanding judge, and they kept on being remanded to police custody. A petition was filed before the High Court asking the Honorable High Court to term the arrest as illegal. Some of the submissions that illegal arbitrary arrest, no occasion, complete contravention of 41A, and the court also below was required, as far as Arnesh went, to ensure that there was compliance, did not do so, and therefore the arrest is illegal, and the arrest must be quashed and the petitioners must be released forthwith. The High Court was very alive to what we were saying. The High Court granted us an urgent hearing. The High Court gave due importance to liberty of an individual and after hearing both the sides at length, held that the mandate of 41 and 41A was absolutely not compliant. It referred to Until, it referred to Arnesh, it referred to Munawar, and said time and again, this is the mandate as laid down by the Apex Court. It further went on to hold the lax prosecution. It went on to question the need for arrest after 4.5 years, or why the charge sheet is not filed yet. And it also went on to comment on the remanding court of having not satisfied itself by detaining them further without following the dicta of law. So it is a very welcome judgment for criminal jurisprudence that the High Court felt that it was time to give weightage to what the Supreme Court has been saying. And this is again a judgment which is a must read, although the order is for interim bail, but it really very succinctly lays down the provisions and the importance of liberty of an individual. So I know more could have been said on Kochar, but matter is still in court. And this is the heart of what has happened in Chanda Kochar. So with this, I think I've taken quite a bit of time there, but this is the essence of Arnesh, Until and Kochar, that bail, and if I go back to my first slide, right, that personal liberty has to be given its due, though the courts need to balance at times. There are safeguards, there are provisions which balance the right of an agency to investigate, but at the same time, give the importance that Article 21 deserves. Thank you very much.
Very well, sir. So thank you so much, sir. Really means a lot. You took out time and you did this wonderful session. This session was more like a Bible to the law of bails. And the way you prepared this PowerPoint presentation, and through this, you explained all the important guidelines that were laid down by the Honorable Court over a period of time in bails, and repeatedly held that bail is the rule and jail is an exception. So basically, in a nutshell, to all the viewers who are watching, the reason why Chanda Kochar and Deepa Kochar were enlarged on bail or were granted bail was due to non-compliance of the mandate of Section 41(1)(b)(2) and Section 41A and Section 60A of CRPC. That ensure that the benefit is given to the petitioners warranting their release on bail, because the learned special judge below had overlooked the mandate of law as well as the dicta laid down by the Honorable Supreme Court in the case of Arnesh Kumar and Satyendra Kumar Until, as sir had beautifully explained through this PowerPoint presentation. So thank you so much, sir, once again for taking out time for doing this really very important session in the field of criminal law, wherein you examined the judicial pronouncements in detail through this PowerPoint presentation in the case of Satyendra Kumar Until versus CBI and Chanda Kochar versus CBI. To all the viewers who are watching, our email is mentioned on the channel. In case if you still have any queries and questions, feel free to write to us. We'll be more than happy to forward the same to our micers for today's session. So, sir, any parting words before we finally wrap this up towards the end of the segment? Anything that you...
It was, I think it was wonderful, Jay. Thank you again for organizing. And I hope the viewers benefit from the session. And I hope more than that, that the practicing lawyers use this more often in court and ensure that these judgments are given their due and that the liberty of an individual is protected. That is my real hope.
And sir, we hope to bring you back for another episode on our channel, and then talk about Chanda Kochar in detail once there is a final verdict. To all the viewers who are watching, the matter is still sub judice; it is pending adjudication. So I don't think it's appropriate for us to delve into the merits of the matter. But as far as the bail order is concerned, we've already discussed that in great detail. So sir, thank you once again for taking our time for doing this session. It's goodbye for now.
Thank you. Bye. Bye.